Alright, 221, Georgia Code, Title 12, Conservation Natural Resource, Chapter 17, Petroleum Pipelines, Definition 1217.1. As used in this chapter, the term board means the Board of Natural Resources, the Director means the Director of the Environmental Protection Division, the Department of the Natural Resources. The Division means Environmental Protection Division, and the Department of Natural Resources with existing petroleum pipeline means the petroleum pipeline construction and use prior to January 1st, 2016. Expansion means the modification of existing petroleum pipeline, existing easement over the right-of-way with the increase of supply of petroleum by increasing the diameter of the existing pipeline, constructing parallel petroleum pipeline. Extension mean with a modification existing petroleum pipeline, increase the length of the footprint existing petroleum pipeline, distance greater than 1 linear mile with the main maintenance means care on keeping the existing petroleum pipeline and prudency for the replace existing petroleum pipeline, same easement over the right-of-way relocation existing petroleum pipeline, prepare 1 linear mile with existing petroleum pipeline alignment. New petroleum pipeline means with the petroleum pipeline was not constructed with the use of the prior January 1st, 2016. This new petroleum pipeline shall not include the expansion, extension, and any maintenance. Parallel petroleum pipeline means with the petroleum pipeline run inside with the side existing petroleum pipeline not fixed means a fixed conduity constructed with the transport petroleum products in another state. 12 petroleum pipeline company means with the corporation organizational law of the state which organized under the law of another state with the authorized to do business with in the state with a specifically authorized charter and article with the incorporation construct the operate petroleum pipeline for transportation petroleum products. Chapter 17 Petroleum Pipelines 1217.1 Definitions. Permits required 1217.2. On and after July 1st, 2017, construction of new petroleum pipeline extension for the state shall require the permit with the director provided within this chapter for the no construction activity portion of the new petroleum pipeline. Any extension shall occur in left until such permit is obtained. Such permit shall be required with regard whether the petroleum public company intends to exercise any power eminent domain pursuant to Article 4, Chapter 3 of Title 22 shall be the addition of any of the permit authorization required under this title and any other provisions of the state and federal law. 1217.3 Permit Application Requirement Notice. Any application for the division of the permit used for the chapter shall contain with a minimum of the following stating information included but not limited to map show of the proposed location route of the new petroleum pipeline extension, information contained with a cultural assessment conducted along with the proposed route of the new petroleum pipeline or extension, information with the geological hydrological feature of the proposed route of the new petroleum pipeline with extension, information presence of the presence of a threatened and endangered species along with the proposed route with a new petroleum pipeline or extension. Environmental information described in Title 40 CFR of Section 1502.12 through 1502.18 as provisions exist in January 1st, 2007. The consent is required. Rules, regulation of the board, evidence, financial responsibility by petroleum pipeline company. 70 other information from the board may require rules, regulations within 10 days after applying the permit. Application shall public notice legal organ in each county with the proposed route of the new petroleum pipeline extension to be located. 12 of the written and following the application code say shall all landowners whose property is located within 1,000 feet of the proposed new petroleum pipeline extension such notice shall be delivered to each landowner containing the following language of boldface type. Your property is located within 1,000 feet of the proposed petroleum pipeline which an application for the permit has been filed with the pursuant to Chapter 17, Title 12 of the Official Code of Georgia and noted. Said chapter along with the Article 4, Chapter 3, Title 22 of the Official Code of the Georgia and noted provide with a specific requirement with must be filed with the petroleum pipeline companies before they may build the new petroleum pipeline or modify an existing petroleum pipeline. The provision of the Official Code of the Georgia and noted also provides specific rights for your protection. You familiarize yourself with the requirements and your rights. 1217.3 Permit Application Requirement Notice. Consideration in permitting, making the decision to revoke the grant and permits with the required for the chapter, the director shall determine with a portion of petroleum pipeline which permit is not consistent with and not undue with the hazard of the environment, national resources of the state with either consideration following facts with the information required to contain with the petroleum pipeline company's application section or in section 17.3 with the director enforce environmental impacts, proposed new petroleum pipelines or proposed extension. 3 alternative alignment, proposed new petroleum pipeline, proposed extension, public comment. And 5 such other factors the director deems reasonable, applicable for the board or board and by rules, regulation established in order to protect the best interests of the state, its citizens, natural resources. The application shall bear the burden of proof of the demonstration of the director should issue the permit and provided under this chapter. The director's decision shall be based recorded before the director, which include but not limited to the application submission, written comments submitted to the director, research for the director may conduct in analyzing the application. Alright, 12.17.5. Aggrieved and adversely affected the defined administrative review. As due to this code section of the term aggrieved is adversely affected with the meaning of the challenge action with the cause of the personal injury and the fact with where the injury of the interest within the zone of the interest to be protected, regulated provision of the chapter direction with the empower to administrate and enforce any person with aggrieved adversely affected with the decision acting with the direction of the chapter shall, upon filing a petition 30 days after the issuance of the order of the taking of such action, has a right to the hearing of the administrative law appointed by the board. Hearing before the administrative law judge conducted in accordance with chapter 12.13, title 50 of the order administrative procedure for the administrative law shall constitute final decision of the director. Any of the part of the hearing, including the department, shall write of the judicial review thereof in accordance with chapter 13 of title 50 Georgia Administrative Procedure Act. C. An event where the director asserts the position response into the position of the administrative law judge of the petitioner is not agreed with the adversely effective administrative law judge shall take an evidence here of the arguments on this issue, thereby making a ruling on the same before continuing with the hearing. The burden of going forward within the evidence for the issue shall rest with the petitioner. Alright, 12.17.6. Rules and Regulations. No later than July 1st, 2018, the board shall be pursuant to the chapter 13, title 50 of the Georgia Administrative Procedure Act, propagate such rules and regulations necessary and responsible for the personal enforcement chapter, which should include but not limited to submission, permit, application, provision for the application review profit not exceed with 150 days in length with a provision non-refundable application fee, which should be sufficient to defray the administrative cost of the review of the application and with the division. 3. Reasonably public notice of filling permit applications with the landlord who, after the reasonable efforts to come in and not personally begin within those required in subsection B of the code section 12.17.3. 4. Provision of public meetings held prior to any action with the permits. 5. That evidence of financial responsibility required in paragraph 6 of subsection A, code section 12.17.3. No permit shall be granted with the division prior to the promulgation rules regulations provided within this code section, provided however one such rule regulations have been promulgated applications are, except for the following: if the application is not approved, it is denied within 150 days if the trust application is filed with the division under section code 12.17.3. The application shall be deemed to be approved by operation of law. And that was Conservation Natural Resource, Chapter 17, Petroleum, cross-reference, eminent domain, petroleum pipeline 22380.